heard appeals on the matter of Saxon Woods Investments Limited and Costa and others.
Yes, Lord Robson.
Good morning, my lords. As the court knows, I appear with learned junior Ms Patricia Burns for Mr Costa. I say that because with the permission of the court, my learned junior is going to address the court on ground 7 of my learned friend's appeal, the costs point.
Yes.
That, in order that people watching can hear her as well as the court can hear her, that might mean that we'll need to move around at an appropriate point, and I just seek the court's permission and indulgence for that.
Yes, of course.
I'm grateful. My lords, the court has seen my skeleton arguments, plural, my learned friend's skeleton arguments, plural. Therefore, because there are consolidated appeals, the court has had the benefit of 100 pages of written material. I use the word benefit somewhat in italics. I'm not therefore going to deal orally with every point. I'm going to seek to focus on my oral submissions on what we regard as the main points, and the points the court actually has to decide in order to determine the appeals. There are a number of points which may be interesting, but don't actually arise, we say, for determination. There is one point I want to make right at the start, and arises out of various gauntlets thrown down by my learned friend yesterday during his submissions, and that's this. We are not running our appeal, nor do we respond to my learned friend's appeals on any facts save those as found by the judge, nor are we challenging any of the judge's factual findings. I want to make that absolutely clear. It ought to go without saying, I hope it's now very clear. We are focusing on the legal points. Given that, and to present my submissions in the way I think will be most helpful to the court, I propose to start with my own appeal because the contract points are really logically prior to everything else. I think that will make my submissions easier to follow. So I'll deal with my appeal, then I'll respond to my learned friend's appeal. I will, of course, clearly signpost which point I'm on at all times. So I hope that's acceptable to the court. Therefore, let me start with the contract points, which really starts with ground 1 of my appeal. And as the court knows, we're looking initially at clause 6.2 of the contract, which is in core 18 at page 533. We've looked at this a number of times already, but just allow me to point out one point right at the start and to explain what I mean by first phase and second phase. I think the court is now aware of this already from learned friend submissions, which is you can put a line before the last word of the 4th line, i.e. after, during the course of the investment period, and before in, and that's where the second phase starts. And it's common ground that in the last line, during the investment period, is an error, and it should be as soon as reasonably possible, or some such words. Now, what I propose to do is to spend a bit of time first explaining in overview what we say the clause does, and then go through the judge's approach and my learned friend's approach, and explain in our submission why our construction is correct. What I want to do first is to set out an overview, and looking first at the very first sentence. The first phase has 2 sentences. The first sentence is phase 1, and the second sentence is phase 1. Now, what does the first sentence of phase 1 do? In my respectful submission, it does 2 things. First, it imposes a contractual obligation to work in good faith towards an exit. Second, and importantly, it defines investment period. The clause is headed investment period. There's the usual rubric in the definition section which says you're not meant to look at the headings. And I'm not basing this on the heading, but just to be clear, it's clear from the heading and also from it says the quotes investment period underlined, and the underlined obviously is i.e. this is a definition, that the first sentence is doing those two things. It's imposing a contractual obligation and it's also defining the investment period. And in order to understand and interpret the clause properly, in my submission, you have to realise that both of those purposes are important to the draftsperson in that first sentence. It's not only an obligation, it's also a definition. But it's not only a definition, it's also an obligation. And what the first sentence means, and I'll develop this, is during the investment period, i.e. until the 31st of December 2019, the company and the investors have to work together in good faith towards an exit. But to be clear, and this is one of the elements of common ground which I'll be coming to, failure to achieve an exit by the 31st of December 2019 is not in and of itself a breach. That is common ground, as I understand it. So that's the first sentence. The second sentence...
Sorry, can I just
yes.
interrupt there?
Yes.
You said what it means is during the investment period they have to work together towards an exit.
In good faith.
In good faith. You've ignored the words no later than 31st December. Why is that?
This is the point I'm on, and can I give my Lord a short answer because I'll be developing this point. No later than 31st December 2019 is how the draftsperson is defining the investment period. And I'm really not dodging my Lord's question, but I'm going to answer it, I hope, by coming to the point I was coming to, which is the second sentence.
Yeah.
Because you have to read the two together. There were lots of cases about interpretation of contracts. My learned friend was not brave enough to cite any to this court, and I'm not brave enough either. But one point which we all agree on is the first sentence has got to be interpreted in light of all the other sentences in clause 6.2, and clause 6.2 has got to be interpreted in light of all the other clauses in the contract. My Lord Justice Zacaroli will forgive me for making that obvious point, and I'm sure that's not in dispute. I absolutely, with respect, understand where my Lord is coming from, but let me continue to answer the question by looking at the second sentence. Second sentence, in addition, come back to those words, the company and each of the investors agree to give good faith consideration to any opportunities for an exit, and then what? During the course of the investment period. Now, the first point is the in addition. It's not really, when you read the second sentence, it's not really in addition in the sense of being really additive. If the second sentence wasn't there at all, of course the parties would have to give good faith consideration to any opportunities for an exit. That would be encapsulated in the good faith obligation in the first sentence. So it's not in addition in the sense of I'm adding something which you wouldn't have known if you'd only had the second sentence. There is a bit of, and this is not unusual as the court will be aware, there's a bit of redundancy, a bit of repetition here. Lord Hoffman, in a case whose name I always forget, talked about the draftsperson trying to obliterate the conceptual target. What the second sentence does is to put beyond doubt, if there were any doubt, that if an opportunity for an exit arises during the investment period, you've got to give it consideration in good faith. Now, importantly, however, and I've got my Lord Justice Zacaroli's question ringing in my ears, and I'm still answering it, I hope. The second sentence is doing more than just obliterating the conceptual target. One of the benefits of repeating oneself in slightly different terms is that sometimes the repetition clarifies what you meant the first time. And that's the case here. Because the second sentence is really subsumed within the first, the repetition sheds light on what the first sentence means. And in particular, look at the endings of the two sentences. First sentence, no later than 31 December 2019, and then the quotes, investment period quotes. That's the definition of the period of time, which is the investment period. Second, during the course of the investment period. And in these two sentences, in my submission, so far as the obligation is concerned, they fulfill the same function and mean the same thing. They're in different words because in the first sentence, the draftsperson is trying to do the definition of when the investment period ends. And that's important for the draftsperson because the one thing we know is that when we get to phase 2, i.e. 1st of January 2020, we're in a different world contractually, i.e. there are obligations in phase 2 which do not apply in phase 1. And so the first sentence means, in my respectful submission, during the course of the investment period, the company and each of the investors agree to work together in good faith towards an exit. And the reason why it's been drafted in this slightly roundabout way is because it's also a definition. It's trying to do two things at once. The draftsperson didn't do one of them very well. But once you read it with the second sentence, which is the second sentence of the first phase, in my respectful submission, it's clear both what the draftsperson was trying to do and what that first phase means. And we call, and the court may or may not find this helpful, that we call that first phase really the protective phase, i.e. the good faith obligation protects the party's goal to exit their investments at the end of the investment period. That was their goal. However, if an exit has not in fact been achieved by the 31st of December 2019, then, and we end up in phase 2, the directors must engage an investment bank to cause an exit as soon as reasonably practicable and or within a reasonable time after 31st December 2019 on such terms as consented to by the directors, such consent not to be unreasonably withheld. And we see phase 2 essentially as a prescriptive phase in distinction to the protective phase of phase 1. And it contains more stringent obligations. Now, I'm going to develop all of that, and I'm sure the court may have more questions, but I will develop all of that. What I would like to do before I do that is to set out 4 items of common ground, because it's important that we really grasp what is common ground in this case, because otherwise we can be led astray by putative interpretations which are then denied by the common ground. So let me next do, if I may, the common ground. And there are 4 elements of common ground. First, the one I've already mentioned. It's common ground that there was no obligation actually to secure an exit in the investment period or at all. If I may, because the court has already seen quite a lot of these references in the judgment, I'm going to give the court references, except where I think we really need to go back to the judgment. In other words, just to sort of support my point that this is common ground. I hope that's acceptable. It will certainly speed things up. So that's at Judgment 196, paragraph 196. It's in my learned friend skeleton at paragraph 9. And so that, and obviously that's our case as well. So that's the first element of common ground. Second element of common ground, it's common ground that there are 2 phases within clause 6.2. Indeed, learned friend made this point yesterday. And as I said, we call what's to happen during the course of the investment period, i.e. until the 31st of December 2019, the protective phase, and what's to happen after the prescriptive phase. Now, the third and fourth points of the common ground also relate to that 2-phase structure. Now, Mr Costa's appeal relates to the first phase, but as I'll come on to explain, the second phase necessarily informs the construction of the first, because you've got to construe the clause as a whole. And I will come back to this point, but one of the problems with my learned friend's approach, and we'll see this later when we look at how he puts this in his skeleton, is that his approach essentially collapses the 2 phases. It does it in 2 ways, and I'll be dealing with each of these. First of all, it imposes a hard obligation at the 31st of December 2019, in the interchanges yesterday between my learned friend and the court, a low ball offer on Boxing Day is going to win you the company, essentially. And the second way he collapses it, and we'll see this, is that he says, actually, you've got to retain the investment bank in the first phase. That's part of your good faith obligation. Invariably, he says, it will be required, his words, to retain an investment bank in the first phase. Now, we say respectfully that has to be wrong because that collapses phase 1 and phase 2. I'll come back to all those points. But the third point of common ground relates to that. The third point of common ground is that certainly within the second phase, you've got to retain an investment bank. And that brings us to the point that in the last line, during the investment period, when I say the last line, I mean the last line on the print. That is a typo. That's obvious. The judge recognised that. It's just bad drafting. It also, of course, shows that perhaps the whole of clause 6.2 wasn't drafted with the greatest care, but whether that really takes us much further may be doubtful. Now, the judge held that it was an implied term that within the second phase, and I'm quoting now from the judgment at 193 to 194, the exit must take place as soon as reasonably practicable and or within a reasonable time after the 31st of December 2019. And Mr Costa doesn't appeal against that holding or finding, when it's a holding. Fourth, the last element of common ground, and again I've mentioned this, it's common ground that the second phase imposes more stringent or robust or harder edged. I think robust and harder edged are words that my learned friends uses. I'm taking that from his skeleton 31.2 and 40 than the first phase. And I've already highlighted the point, and I'll develop it, that we say that his construction ignores really this common ground. So the first phase of 6.2 therefore means something less than the second phase. The central question therefore is what? Now, I've set out in short what we say it means. Before I develop that, let me, as I say, come to how the judge approached it. And I appreciate that because this is a point of law, this court can approach it essentially de novo anyway. But I hope it's both helpful and indeed fair to the judge to take the court through the way the judge approached it and to set out our respectful criticisms of the judge's approach. Now, we respectfully submit that the lack of real analysis in section 9.1 of the judgment, which deals with the construction points, is striking. That's especially the case that when one remembers that at trial, the petition really turned on the construction of 6.2. As I'll come on to explain when I deal with my learned friend's appeals, the section 172 point was certainly given much less prominence at trial than my learned friend now seeks to give it in this court. And I'll come back to that. Now, if I could invite the court to pick up the judgment, and of course the court has been taken to a lot of this, for which I'm grateful, and I don't want to trespass on the court's patience by taking my lords back to passages you've already looked at, but I need to take you back, if I may, to some of them in order to develop the argument. So can we please look at 183, which is at page 238. And we respectfully say that this exposes the problems with the judge's approach. When he says from the third line, the idea that an obligation to do something by a particular date is satisfied by making preparations before that date to do the thing after that date is an odd one. The company's obligation was to work in good faith towards an exit by a specified date. Now, my learned friend calls this construction unimpeachable. That's his word. But with respect, it's not really a construction at all. He refers to paragraph 196. And if we just turn to 196, the learned judge says, third sentence, 4 lines down, what the parties agreed was that the company and the investors would work together in good faith towards an exit by a specific date. With respect, that isn't really a construction at all. That really restates the words of the clause. But coming back to 183 and how the judge passes it or interprets it, and to continue a little later down in 193, deciding, and I'm about, I think, 7 or 8 lines down, deciding not to take any steps to market the company prior to that date cannot possibly constitute a reasonable attempt to fulfil that obligation. The same, I think, is true of a decision to take preliminary steps, but not to perform that obligation until a specified time in the future. And the problem at the heart of paragraph 183, we submit, is that it assumes that there was a definite something that the court was obliged to do, sorry, the company was obliged to do, by the 31st of December 2019. The repeated references to that obligation. And indeed, that's the only way one can make sense of the references to preparatory or preliminary steps being insufficient. It doesn't make sense to talk of preliminary steps to work in good faith towards something. There has to be a definite something to be achieved. The judge never identifies, at least in this section of the judgment, what that something is. But it's clear that the judge is focused on an obligation, as he puts it in the 4th line, to do something by a particular date. Now, as we say, it doesn't make sense to have a hard deadline for an obligation to work together in good faith. The purpose of a good faith obligation is to regulate the parties' behaviour over a period of time.
I mean, it must be the case, surely, that prior to the 31st of December 2019, the company was obliged, in fact, the parties were obliged to do something.
Yes, absolutely.
And the something was to work together towards a particular result by that end date. Now, the result didn't have to happen by the end date in the sense that it would be a breach of duty if it didn't. I think that's common ground. I can see that. You know, in other words, it's not a breach of the agreement that it doesn't happen before the end of the year, but it's plain the company and the parties were supposed to be doing something before the end of the year.
Yes. And
the question of what is somewhat open-ended, but so's the process of arranging an exit.
I'm very closely allied to the way my lord has put it, not entirely. That we have to distinguish between two things. An obligation to work in good faith, to do something by the end of the year, and an obligation, which I think is the way what my lord has just put to me.
I didn't say it's not an obligation to work in good faith to do something. It's to work in good faith towards a result.
Okay, towards a result by the end of the year.
Yeah.
It's essentially what my lord's putting to me.
Yeah.
And an obligation to work together in good faith during that year to do it. And there's an important distinction, and this is the distinction I'm making. And as I'll develop, I hope, the benefit and the obvious commercial benefit of my approach is that it gets us away from the lowball offer on Boxing Day. The learned friend has a problem with the lowball offer on Boxing Day, and I'm using that as a shorthand, but we know what we mean. Because we all agree, the fact that there's no offer by New Year's Eve doesn't mean you're in breach.
Correct.
But on his approach, a lowball offer on Boxing Day, if that's the only offer on the table, as I understood his submissions yesterday, you've got to accept, essentially. Now, the key to the clause, and I do underline this point, the key to the clause is to recognise that the first sentence is doing those two things. It's the obligation, which is what I'm now discussing with my Lord Justice Snowden, but it's also the definition. And until the 31st of December 2019 is defining the extent of the investment period. That's when the investment period ends. What you have to do is during the course of the investment period. The words until the 31st of December 2019 in the first sentence fulfill the same function as during the course of the investment period in the second sentence. And once one realises that, and once one reads the first sentence and the second sentence, which are essentially very similar obligations in the first phase, and the second sentence is in addition, you see the answer. Because once you read during the course of the investment period into the first sentence, there is the answer. The reason why it looks like a hard edge, you've got to do it by the 31st of December, is because the words in the first sentence, no later than 31st December 2019, that's because the draftsperson is also at the same time trying to answer the question, when does the investment period end?
The points you're making about paragraph 183 are dependent on that construction.
Yes.
6.2, I think that's right.
Yeah, exactly. I'm criticising the. I've stopped saying respectfully, because I hope we can just take that as read. I'm criticising the judge's judgment because I'm saying he's saying there is an obligation. I was about to come to what we see that obligation is, and I'm going to be submitting that isn't a clause 6.2 obligation. Exactly, yes. My Lord, I'm going to be developing, my Lord, Lord Justice Snowden, my answer to the point I've just briefly answered. So, can I carry on? And I hope I'll answer the question more fully as I carry on. Obviously, if I haven't, I'm sure my Lord will come back. So, to pick up the point which Lord Justice Zacaroli put to me, what is it that the judge thought the company had to have done by the 31st of December 2019? He keeps talking about that obligation. Now, section 9.1 of the judgment, which deals with the construction point, doesn't tell us. But it's clear from other parts of the judgment that the judge really concluded that the company was obliged to procure final and binding offers by the 31st of December 2019. And really, if one reads the judgment as a whole, that's really why he held the company to be in breach of the first phase of clause 6.2. And, for example,
doesn't that, aren't you, I don't know, I can't remember what the suitable analogy, whether you're erecting a windmill to tilt it or whatever, but as I read 183 in the middle of it, deciding not to take any steps to market the company prior to the date, he says, cannot possibly constitute a reasonable attempt to fulfil that obligation. In other words, I didn't read him as actually saying the company must obtain final and binding offers before the end of the year, but you must at least give yourself a chance for that to occur. If the company or one of the parties just said, we will not even go into the market and invite offers before the end of the year, then, in a sense, I think he's saying that can't possibly be working in good faith towards an exit by that date. Because you're sort of slightly caricaturing it by saying that he found that the company had to obtain a final binding offer by the end of the year and you'd be in breach if not, and that's the interpretation he's put on the clause. And I'm not sure he's gone that far, has he?
Well, to a certain extent, it doesn't matter whether he has or he hasn't. That, in the sense that the central point is that we all agree that a construction which requires the company to have procured offers by the end of the year is certainly too prescriptive and not supported by the language of the clause. Now, what you have, we say, is a good faith obligation to work together towards an exit. And in our submission, the duration of that good faith obligation to work together towards an exit starts when the contract is written and ends on the 31st of December 2019. Now, it's not necessarily the case, we respectfully submit, that if you didn't do anything, you're necessarily not giving good faith, working together in good faith. If you take the view that, you're situated in the middle of 2019, you take the view that actually the sort of prices you'll get now are far lower than prices you'll get in 9 months' time, and actually it makes much better sense to wait for 9 months. We would respectfully say that's not a breach of the clause.
Well, hang on a second, it depends on what capacity you're doing that.
Yeah.
I mean, if you look at the clause 6.2, if you, as the company, say, or if you cause the company, in a sense, to take that view and not to, therefore, to shut the door on any opportunities for an exit before the end of the year, that might be a breach. But the second sentence, I think, makes it, at least on the face of it, makes it clear that the company and each of the investors are not obliged to accept it, such an opportunity come what may, because it just says they agree to give good faith consideration to any opportunities for an exit in the course of the investment period.
Yes.
So, qua shareholder, you're not obliged to accept any old thing that's put in front of you by the end of the period.
Yes.
But qua company, to whom the offer is not made,
Yes.
you are at least supposed to do something so that the opportunity can arise before the end of the period. In other words, if you, the company, just shut your mind and say, I am not going to invite any opportunities before the end of the period, so that nobody will get a chance to consider them, why isn't that a breach?
Well, it will all depend on the facts, but if the facts are that no offer, that no offer that's going to come in is going to be acceptable to the investors, for example, or that there is something going to happen in your industry which is going to make your company infinitely more valuable in February 2020, then it's not a, we would respectfully say...
Why is it for the company to take that? It's not for the company to make its mind up for the investors.
Yes.
I mean, it's clear that it's the investors who are going to be the persons to whom the offer is made. The company doesn't own its own shares.
Yeah.
The company's job is to procure, and it's the investor's job to decide.
Absolutely.
And so why can the company take it upon itself to say, I know best, I'm the company, I know best. I'm going to deprive the investors of the opportunity to do what the second sentence gives them the opportunity to do, to give good faith consideration to any opportunities that arise.
But
That's the case I think you're actually facing. It's that your client, effectively acting in his controlling role of the company, effectively took it upon himself, qua company, to simply deprive the investors of any opportunity to consider an exit before the year end.
Right. So if I say, again, I won't say respectfully, because that will be taken as read, I hope, as well. I think our exchange has now moved from, so to speak, duty or construction of the obligation to breach.
I was trying to identify, in a sense, on whom the obligation is placed to what.
I appreciate, exactly. So part of what I was going to respond to my lord, I will deal with when I come to the breach part of my submissions. And of course, I accept that this court has to, so to speak, look at both. But I just want at the moment just to stay, if I may, on the construction point, and I'll come back to the breach. Obviously, the breach depends on what the obligation is, to make the obvious point. Ultimately, we see what the judge has done. Ultimately, because we're in the course of appeal, and this is a point of construction, which, as a matter of English law, the meaning of a contract is a point of law. Ultimately, it's for this court to decide what the bargain means. And let me therefore turn to, so to speak, start afresh by looking at the clause and doing the construction exercise as we respectfully submit it should have been done. And as we submit, to reiterate, we submit the clause means during the investment period, i.e. until the 31st of December 2019, the company and the investors have to work together in good faith towards an exit, sentence 1. Also, during the investment period, the company and the investors have to give good faith consideration to any opportunities for an exit. That's the first two sentences. And then, if there hasn't been an exit by the 31st of December, the directors must then engage an investment bank to cause an exit as soon as reasonably practicable thereafter, on such terms consented to by the directors and not to be unreasonably withheld. Now, as I've said, I'm not going to cite any authorities. The only one I'll mention without formally citing it, Rainy Sky. Obviously, we're told that we have to do the iterative approach, look at all the relevant factors. I'm really not going to say any more about that. But the first thing we should look at is the contractual context, and I've touched on this already. The obligation to work together in good faith towards an exit no later than 31 December 2019 is just one part of a single clause, and is not even the whole of the first phase of clause 6.2. And you need to read 6.2 as a whole to understand what each part adds to the overall exit mechanism provided by the clause. Now, the second phase, as I've said, imposes more stringent obligations, and it may be worth just reminding ourselves what the company has to do in the second phase: engage an investment bank to cause an exit. Now, since the investment bank can't actually cause an exit, that being a decision ultimately for the shareholders, what it must mean is, conduct a sales process leading to a valuation, etc. That all as soon as reasonably practicable after 31st December, and then there's a valuation devised by the investment bank on such terms as the directors consent to, such terms not to be unreasonably withheld.
What is that? Sorry, you may be about to dissect this clause, but I've got two questions. The first is, what does at a valuation devised by such investment bank actually mean?
Yeah, it's as I read that, it's the board of directors engages the investment bank. It comes back to where it says to cause an exit. That really must mean, in my respectful submission, the way I put it a moment ago, was to conduct a sales process, leading to an offer at a valuation. Okay. Because otherwise, it doesn't really make sense.
Yeah. Right.
If I can put it in this way, it's truncated. Really what it's saying is it's a truncated form of the directors must hire an investment bank, the investment bank will go out and do what investment banks do, come back and say to the directors, here is an exit, capital E, and that's at a valuation devised by the investment bank really is an exit at a value which the investment bank has got, if I can paraphrase. This is the only way, I think, to make sense of what the clause is doing. And on such terms, i.e. an exit on such terms, as shall be consented to by the board of directors. So the board of directors has to consent to the valuation and the terms of the exit, but that consent can't be unreasonably withheld. That's how I read that section of phase 2.
I mean, it's quite curious, isn't it? Because normally it wouldn't be for the board of directors to consent to anything other than the sale of assets by the company. I mean, board of directors doesn't normally consent to the terms on which shareholders can sell their shares.
Yeah.
I mean, it's unusual.
Yeah.
The other thing that occurred to me is that clause 3.5d we haven't looked at. But I mean, that's actually designed to break the deadlock between. It's a deadlock breaking provision between shareholders.
Yeah.
Which is a sort of buttresses the point that there's in fact a variety of mechanisms to ensure one way or another that there's an exit achieved after the end of the year end, even if it hasn't been achieved prior to the year end.
Yes, I'm certainly not going to push back against the proposition that once you hit the 1st of January 2020, you're in a new world. I mean, indeed, that's actually part of my submission. Part of my submission is the danger of reading the 31st of December 2019, the way my learned friend reads it, and I would submit the way the judge reads it, is that you end up, although you say, well, you're not in breach if you haven't sold it by the 31st of December, if there's an offer, the way my learned friend puts it, you've essentially got to take it by the 31st of December. The way I read the clause is that that's not right. The good faith obligation is during that period. But I certainly accept that whether it's because phase 2 imposes more stringent obligations, and also because the way 6.3 Roman 2 kicks in, especially in phase 2, and or because of 3.5D, once you're in phase 2, it is harder edged, yes. Now, even just continuing that point for a moment, however, and without resiling from what I've just said, I think I said it's much more hard-edged. Even in phase 2, we need to recognise that there is flexibility. Even in phase 2, there is no hard deadline. Even in phase 2, there is no fixed timetable. Even in phase 2, the directors, provided they're acting reasonably, or not unreasonably, can refuse consent to the exit terms proposed by the investment bank. So even in phase 2, the directors can turn down a deal without putting it to the shareholders, provided they're not acting unreasonably. And so if, for example, let's just take an example, the investment bank came along with proposed terms, say in March 2020, but the directors were very close to securing a much better offer from a different putative counterparty. The second phase of clause 6.2 would allow them to withhold consent to the investment bank's proposed deal in order to pursue their own better deal. In other words, even in the second phase, it's not you've got to exit by D date at any price. And there is no sensible basis, we submit, for construing the first phase as providing less flexibility than the second. But we say if you treat the 31st of December 2019 as a hard deadline in the way my learned friend does, that is where the construction, that is what that construction does, and that is the problem. For example, on my learned friend's construction, the directors would not have the flexibility I've just mentioned in the first phase. Working in good faith towards a better deal in 2020 would be a breach of the first phase because, he would say, the company wouldn't have been working in good faith towards an exit by the 31st of December 2019. And my Lord Justice Zacaroli asked my learned friend yesterday, at pages 143 to 144 of the transcript, whether it was open to the shareholders to reject an offer in either March 2019 or December 2019 on the basis they wanted to hold out for more money in 2020. And after a little bit of hesitation, my learned friend's answer, I think, was it would be open to reject an offer in March because a ship could come in before December, but not in December because that's the last chance to hit the deadline.
I think that he may have said that the first time I asked the question, but later on he didn't say that because he said 6.3 Roman 2 at the end applies throughout. So the shareholders, if the proposal is put to them, are obliged to procure the exit in accordance with that proposal at any stage. I think that's his answer.
So in other words, he sticks by his answer for December 2019, but says it's the same answer for March 19. Yes, exactly. Yeah. That is, I mean, I can come back to that point. The point I'm on at the moment, however, is the December 19 to January 2020 distinction. Because of, on that approach, certainly when it comes to December 19, well, first of all, we would say that in March 2019, your obligation is to work together in good faith towards an exit. And you can certainly do that in my respectful submission by saying, I've received an offer of X, I'm confident I can get 3X in, say, November, so I'm not going to go down this one. So that deals with the March 19. But when it comes to December 19, the problem with Malone and Friends approach is that the potential purchaser can swoop in, it's the Boxing Day lowball offer, in circumstances where, because you're nearly up against the New Year's Eve deadline, you have to take it. And we do respectfully say that is commercially absurd. And if it's commercially absurd, it's not going to be, in a commercial contract, the correct meaning of the contract.
I'm sorry, it may be me, and I'm not, and I may be disadvantaged alone in court because I don't have a copy of the transcript of yesterday. Okay, I don't know whether I have a temporary clerk at the moment, so I don't know whether the transcript's been sent.
It has. We can certainly. We'll provide. Does my lord? Would my lord want it electronically or in hard copy?
I can send it to you.
Yeah, I can get it electronically by the sound of it.
Definitely soft copy, but that would be very helpful.
Yeah. Okay, it's just it hasn't reached me.
Oh,
no.
But I'd have to have a look at this. But if the last bit of 6.3, I Roman 2, procure as far as it lawfully can that such exit is achieved in accordance with such proposal. If you look at it, 6.3, if an exit is proposed in accordance with the terms of this agreement, each of the investors shall, and then 2, procure as far as it lawfully can that such exit is achieved in accordance with such proposal. I must admit, I didn't understand, Mr. Davis, to say that as soon as the very first exit proposal is received, that everybody has to just say yes. Even in March 2019, because on the face of it, if somebody says, well, there is a proposal for an exit, no matter how bad it is, made in March, forget the low ball on Christmas Eve, just let's have a real low ball in March.
Yeah.
I didn't understand, or if this is what the argument is, I'll push back in reply, but I didn't understand him to say that as soon as the first one comes in, hey presto, because of the last little bit of 6.3, it's got to be taken. That's it. Bang, you're done. First one in gets the exit. If that's what was submitted, that passed me by.
Right.
And if it was, you don't need to answer it because I'll have some more.
I think my understanding is Mr. Davis entered a caveat in that, which was that proposal is proposed by the directors. So when the directors propose it, shareholders must consent to it.
Yes.
In accordance with this the terms of this agreement. But
Yes.
Whereas the terms of this agreement do prescribe what the directors must do in relation to a proposal in the second phase, the terms of the agreement do not prescribe any such thing in the first phase.
Exactly. And I mean, it seems to me, if I may say, that there are really sort of two routes through on this. One reading is, if an exit is proposed in accordance with the terms of this agreement, because, as my Lord Justice Edis has just said, the proposal in that sense comes from directors, which is phase 2, that would mean that 6.3 Roman 2 will only be applying in phase 2, i.e. in circumstances where the directors have had their ability to say no constrained in the second phase because they can't refuse consent unreasonably, the investors similarly have their ability to say no constrained by 632. That's one way of reading it. The problem comes if you read 632 as applying also in the first phase. Now, of course, it does say at the beginning, if an exit is proposed in accordance with the terms of this agreement, which you might say will includes the whole of 6.2. But that then brings us back to the question of, is proposed is really only phase 2 in 6.2.
Although curiously, the second phase, as far as 6.2 is concerned, doesn't include the words proposal at all. It doesn't indicate any proposal. I mean, it's the board of directors simply have to consent to such terms which are devised by the investment bank. It'll be the investment bank proposing it and the board of directors consenting, apparently.
With respect, I absolutely agree. And another potential problem, I mean, this is not well drafted. I think we all can agree with that. Another potential problem is that 6.3 Roman 1 is really much more phase 1 than phase 2, if I can put it in that way. Because in phase 2, you've got the investment bank doing all of this stuff. Now, I appreciate the investors might need to help out the investment bank, but there's a lot of stuff, if I can put it that way, in 6.3 Roman 1, which is really more phase 1.
So that submission, if it next is proposed, covers both phase 1 and phase 2.
That's one way of reading it, but the problem with that is that you end up with a very uncommercial and hard-edged 632 applying in phase 1, which gets us back to the March 2019 point.
Well, but only if it's proposed by the directors.
Only if it's proposed by the directors, yes.
So what is your submission? Do you say that if an exit is proposed in accordance with the terms of this agreement, only applies in phase 2 or also applies in phase 1? What's your case?
Well, I was going to come to my case on 6.3 a little later, if I may, because we come into 6.3 in a number of parts of this appeal, and I'll be coming back to 6.3, if I may. Can I please speak, hold that? Just focusing at the moment, and I appreciate we need to read 6.2 and 6.3 together. If I can just stay for the moment, if I can, on 6.2. Can I just pick up, certainly the way my learned friend puts it, so we can see, so to speak, the contrary argument. He sets this out in his skeleton at paragraph 39.2, behind tab 10. And this is where my learned friend is talking about phase 2, but it's instructive because he really comes back to phase 1 as well. It says, while the company is not obliged to engage an investment bank to cause an exit during the first phase, it doesn't follow it's not obliged to conduct a formal sales process during the first phase, a process which would invariably entail the appointment of an investment bank. To the contrary, its good faith obligation to work towards an exit by no later than 31st December would require it to take such steps. And this is part of what I submit as the collapsing by my learned friend of phase 2 and phase 1. And the reason he ends up doing that, and he ends up in this position, all stems from the misreading of no later than 31st December 2019. It all stems from seeing 31st December 2019 as a date by which you have to have done something, as opposed to a date which circumscribes or delineates the end of the investment period. Now, when one looks, so we've had a look at the at clause 6.2 as a whole in order to try and explain what the first sentence means. The other things we have to look at when we're conducting an iterative process is the commercial purpose. And in that regard, the definition of investment period is the period, and I'm picking up the words of my learned friend at 31.1 of his skeleton, is the period during which it was intended that the shareholders would be invested in the company, following which they would exit their investments. And we agree with that approach. It reflects the fact, as the judge recorded at paragraph 102 of the judgment, that these were financial investors looking for a return on their investments within a relatively short period, to whom the most important thing would be the exit price. And of course, the commercial purpose of the exit mechanism, to state the obvious, is to allow minority investors who don't benefit from drag-along rights to recoup their investment without having to sell at a discount. That's essentially what it's doing. Now, in the real world, financial investors do not pick an arbitrary date on which to exit their investments. They may have a preferred time frame in mind, but the actual date of any exit is always going to be dictated by commercially, mainly financial considerations, as at the actual date of the proposed exit. And that might be a bit before the 31st of December or a bit after, as the commercial cookie crumbles. The reason why you have a date, therefore, is not to set a date by which you intend to be out, but by which, or at which, the nature of the obligation changes from protective to prescriptive. And so it doesn't follow from the inclusion of a date that the parties had an obligation to aim their good faith efforts towards an exit at a deadline of the 31st of December 2019, such that efforts for an exit at a slightly later date would amount to a breach of contract. If, of course, a favourable exit can be achieved within the first phase, well, fine. And if that avoids the harder-edged obligations of the second phase, also fine. But that is not required. It's not a contractual obligation. And the good faith obligation is designed to ensure that none of the parties does anything to undermine efforts to obtain an exit during the investment period. But the status of the investors as financial investors militates against a construction which treats the 31st of December as some sort of hard deadline.
But even accepting you shouldn't treat it as a hard deadline, I think you just accepted that if you do something which would prevent that, I can't remember unfortunately I don't have a live note, but the way you probably, I don't know whether you were reading something, but you accepted that if you did something to
deliberately to undermine it,
to prevent it from occurring by the end date, that wouldn't be in accordance with the contract.
Unless, as I say, unless what you're doing is you're saying, I'm not going to work towards this offer because either I've got a better offer coming, in a month's time, or I absolutely believe there's going to be a much better offer coming in a month's time. We're now on breach again, but that I would respectfully submit is not undermining an exit. You may be saying this particular offer isn't one I'm going to put any effort into, but you're not saying I'm going to undermine an exit. Now, if you have an obligation to achieve an exit by a particular date, and you say I'm not going to do anything at all before that date, then it's going to be likely you're going to be in breach of the clause, which is why it's important on my... Okay,
we've got to look at the facts. I understand that. We're going to move on to breach. But if, for example, you're talking to your advisor, if the company is talking to its advisors, let's say in mid-2019, and the advisors say, right, it will take us 3 months to conduct a sale process, to conclude it, and you're sitting there in August, say, if you, the company, say, well, let's just not give the instruction to start until November, because actually we take the view that it would be better not to complete until 2020.
Be better for us, or we'll get better offers? Or?
Well, the company thinks it would be better, for whatever reason, the company thinks it would be better not to instruct its advisors to start the process until a date where it was impossible to conclude a deal before the year end, because the company just takes that view. Why isn't that a breach? Because you're supposed to be working together for an exit with a view to an exit before the year end. So shouldn't you at least start the process earlier, so that at least there's an opportunity, which then, in accordance with the second sentence of 6.2, the investors can decide for themselves whether to accept or not.
The premise of my Lord's question is that there's an obligation to try to achieve an exit by the 31st of December.
It's to do nothing to prevent an opportunity arising before the year end.
But yes, but the corollary of that, I mean, that is generated by the positive that what you're meant to be, if I may say, it must be implicit in my Lord's question. Yeah. That what you're trying to do is to, you're saying, I have an obligation to work in good faith to get an exit by, square brackets, before, close square brackets, 31st December 2019.
And your advisor's saying, we can do that. You know, we can get offers in for consideration before the year end, to be able to complete before the year end. You just got to tell us to start now.
But that's...
And instead, the company says, no, don't think that's right. I'm not going to tell you to start now. I'll only tell you to start at a date which will be absolutely clear on the basis of the advice I've just been given that you won't get any offers before the year end. Is that working together in good faith to achieve an exit before the 31st of December? Doesn't sound like it to me.
But the place where I take issue with my Lord is that is not the obligation. This is the central point we keep coming back to. It's not that you have to work together in good faith to try to get an exit before the year end. It's that you have to work together during that period to try to get an exit. Now, that can be satisfied by working together during 2019 to get an exit in February 2020. This is why by the 31st of December 2019 is so important, because the premise, and I don't want to repeat the point I just made, but if I may say, the necessary premise of the point my Lord has just put to me is reading by the 31st of December 2019 as the time by which the exit should be consummated.
Yes, because I'm just reading the words, annex towards an exit no later than 31st of December. I mean, that's the way the syntax of the sentence runs.
I agree, and if
you're asking us, I think, to read it, agree to work together prior to the 31st of December 2019 brackets the investment period in good faith towards an exit.
It's what I'm saying is,
in other words, you're rearranging the words of the sentence to bring the timing requirement to match the work together requirement rather than where they actually appear in the sentence, which is, or at least it appears, at least on the ordinary syntax, I suggest, to relate to the timing of the exit.
Well, I would agree with my Lord if two things were not in the contract, and they both are.
Right.
The first is, my Lord read the sentence to me and said, I'm just reading the first sentence, but then, with respect, didn't read the first sentence, because the first sentence does not end with the word 2019. We then have brackets, the, quote, investment, capital I, period, capital P, quote, brackets, underlined. And that really is my point, that no later than 31st December 2019, the, quote, investment period, reminds us that the draftsperson is defining as well as imposing an obligation. Point one. Point two, and I know I've made this point, but since my Lord has put it to me, let me just explain. Again, the second point, second sentence, during the course of the investment period. That's really, really important in my respectful submission. If we were to read those words into the first sentence, because that's what it means, because the investment period has just been defined, the first sentence would then be, the company and each of the investors agree to work together in good faith towards an exit during the course of the investment period. Now, we could then have an interesting debate. Do we mean an exit during the course of the investment period, or is it work together in good faith during the course of the investment period? I mean, those are the rival contentions. Now, I'm very happy to have that debate. And in my respectful submission, what is clear when you read the first sentence with the second sentence and then against phase two is that the obligation in the first sentence of the first phase is to work together in good faith during the course of the investment period. And what you're working together in good faith to do towards an exit. Yeah. The exit doesn't have to be in the investment period. No. When I say it doesn't have to be, I don't just mean if you don't have an exit, you're not in breach. I mean, the exit doesn't have to be.
I understand that.
Yeah.
And all I'm sort of trying to put to you, and I think probably, obviously not very well, but is it seems to me what you're trying to do is to rework the order of words in the first two sentences so that you effectively rework it and say the company and each of the investors agree to work together in good faith during the period, the investment period, towards an exit. And in addition, during the course of the investment period, the company and each of the investors agree to give good faith consideration to any opportunities for an exit, full stop. So you're lifting those words during the course of the investment period or no later than the 31st of December and the definition and reattaching it to an earlier part of each of those sentences as opposed to where they actually appear in each case, which appears to, at least on, I would suggest, an ordinary syntactical reading, to attach themselves to the concept of an exit.
Well, if I may say, the Lord Justice Lewison, in his writing extrajudicially, in his book on construction of contracts, makes the point that in almost every debate on interpretation of a contract, the point could be made, well, if the draftsperson had intended X, he could have said,
That's not what I'm doing.
No, but
what I'm doing, I think, at least I hope I was doing, was to do what I think we're told is usually the starting point, which is, what do the words mean? You just look at the words and then start to test them against the other provisions, etc., etc. And I'm just suggesting, I think, that your interpretation does require a little bit of reorganisation of the two relevant sentences.
It involves reorganisation to this very limited extent, in the sense that what it involves is reorganising the first sentence to identify that it's doing two things. It's imposing an obligation and it's defining the investment period. I certainly accept an easy way to do all of this would be to say investment period. The investment period is from the inception of the contract until the 31st of December 2019, right? Then, during the investment period, sentence 1, sentence 2. That would have been a much easier way to do it. I absolutely accept it. And I also accept, I hope realistically, that is where I'm getting to. I mean, that is the construction which I'm submitting to the court is the correct construction of the bargain. I would also accept, in response to my Lord Justice Snowden's point, that if the first sentence wasn't also a definition, this would all be, my argument might be more difficult. I'd still have the benefit, frankly, of the second sentence, which I think is it's a really important point. It's a really important point. Because why doesn't the draftsperson say at the end of the second sentence, no later than 31st December 2019, or by 31st December 2019, when those are the precise words he or she has used in the first sentence? When you put all that together, you recognise, in my submission, that what the draftsperson is doing is defining in sentence 1 as well as imposing an obligation. And so far as the draftsperson is concerned, the last 7 words of sentence 2 during the course of the investment period are the same, so to speak, the same as in this, for the purpose of the obligation, no later than the 31st of December 2019. And you do have the oddity that on the alternative construction, if in the second half of the year a buyer has in mind a very favourable binding offer to be made in, say, March 2020, it would be a breach of the good faith obligation to pursue that transaction in preference to a less valuable offer which would complete on, say, the 30th of December. And that is very, very unlikely, we submit, to be the case. And that's why we say that seeing phase 1 as protective and phase 2 as prescriptive is the way we submit to underline this, to explain the contract. And although that means I absolutely accept that phase 1 becomes, so to speak, less strong because you haven't got that cut-off, the point my Lord was just putting to me, at the 31st of December. Phase 2 is more stringent, and that gives the necessary commercial bite to the clause overall. And so it's simply not necessary, we submit, to construe the first part of 6.2 as imposing an obligation to work together in good faith to conduct a sales process aimed at an exit absolutely no later than the 31st of December 2019.
I think you said that you accepted that the second phase, there's an error, everyone agrees, in the words, during the investment period.
Yeah.
But I think you accepted that means as soon as reasonably practical after the investment period.
That's
Even
what
if you're right on phase 1, there is a reasonably hard edge for phase 2, isn't there? Which is as soon as reasonably practicable after the 31st of December.
Yes, but I agree, save that. The Board of Directors shall engage the investment bank to cause or work together or prepare for, or whatever better verb we're going to put there. I'm looking at the cause and exit.
Yes.
Yeah. During the investment period. So it's the Board of Directors has to engage the investment bank to do it. I'm just picking up. I thought the way my lord put it was that obligation was, so to speak, on the Board of Directors to do it. They've got to engage an investment bank to do it.
Well, we know there's some mechanical difficulties, but
Yes.
however it's to be done, the obligation is to cause an exit
As soon as you
as
can.
soon as reasonably practical after the end of the investment period.
Yeah.
So it would be improper then, wouldn't it, for the directors or any investor to undermine or do anything contrary to trying to achieve an exit by as soon as reasonably practical after the 31st of December.
Yes, that obligation, of course, only kicks in the event that an exit has not occurred by the 31st of December.
But you've got to read, even on your case, you've got to read the clause as a whole.
Yes.
So there may be, on your case, no hard edge to phase 1, but there is a hard edge to phase 2. So during phase 1, you're working towards an exit at the very latest, as soon as reasonably practical after the 31st of December, aren't you?
You've got to have an eye to phase 2. I certainly would go as far as that. And we could have an interesting debate as to whether the obligation, just in terms of phase 2, the obligation on the Board of Directors is to engage if an exit has not occurred upon the expiry of the investment period. For example, I would certainly accept if on the 1st of December, the shareholders were to say, we are not going to, or one shareholder was going to say, we're not going to engage an investment bank until, I don't know, 2022, that would clearly be a breach, yes. Beyond that, it's going to get into a matter of, we're now in the territory of breach rather than obligation.
But if they found themselves starting the whole process from scratch on the 1st of January 2020, wouldn't that necessarily involve a breach prior to that date?
In my respectful submission, no, it wouldn't necessarily. It wouldn't
If they'd
necessarily.
done nothing at all up until that point, so that as soon as reasonably practicable meant a long time because they were starting from scratch, that wouldn't involve a breach.
In my respectful submission, no, because that obligation only arises if an exit hasn't occurred upon the expiry of the investment period. There may be a difference here between, so to speak, sins of commission and sins of omission, in the sense of, in my Lord's example, I don't wish to be asking my Lord a question, but in my Lord's example, it may depend on whether what's happened before the end of December 2019 is simply, so to speak, not doing anything, or actually undermining. I mean, going to Goldman Sachs and Morgan Stanley and querying the pitch, if I could put it that way, that would be different. But it wouldn't necessarily follow, in answer to my Lord's question, that there would be a breach. I think my Lord had the word necessarily in the question, which is why I answer it in that way.
Understood. Thank you.
Everybody would understand, wouldn't they, that this sales process of a company of this magnitude and size wouldn't be just done by putting an ad in I was going to say Evening Standard, but I'm not sure it's still published or takes ads. But choose your favourite
Yes.
newspaper. I mean, this would require an investment bank involvement to conduct any sort of sales process of this magnitude. You definitely wouldn't be acting carefully if you didn't.
Yeah, I absolutely. But my lord, sorry.
So, I mean, to pick up my lord's question, I mean, could the directors sensibly say, or could the company sensibly say, well, we know that it'll take an investment bank to sell this company or any part of its business, but we're just not going to even contemplate that until the 1st of January 2020.
I could be persuaded to go so far as to say perhaps they should turn their minds in December as to which bank they're going to instruct. But once one goes much beyond that, and certainly goes as far as my learned friend in the bit which I read out from his written argument, to say that even in phase one, you need to instruct an investment bank, which perhaps is where my lord's question goes.
That's exactly where I'm going.
Yeah. The problem with that is that the contract expressly provides that investment bank is only in phase two.
No, it doesn't say. It doesn't say only in phase two. It just says, in addition to various other rights, which are debate, deadlock, and the like,
Yeah.
the board of directors shall engage an investment bank to cause an exit at a valuation that they devise. The investment bank devises. That's why I was asking you also about that wording.
Yes.
Nothing says you can't and shouldn't engage an investment bank to conduct a process prior to that date.
I wasn't, my lord, I wasn't putting it into can't or shouldn't, but I certainly was pushing back against the proposition that you read the clause on the assumption that an investment bank would have been engaged before the 1st of January 2020, because shall engage, in my respectful submission, necessarily implies that the investment bank has not heretofore been engaged. And the way phase one works is that you have to work in good faith towards an exit during the investment period. The exit doesn't have to...
Oh, okay. I mean, it seems to be the board shall engage an investment bank to cause an exit.
Yes.
During the investment period at a valuation devised by such investment bank. I mean, that basically is putting the investment bank into a much enhanced position, as opposed to what investment banks often do, which is just simply conduct a process and then wait and see what comes in and then give advice about it.
I absolutely accept both that the investment bank in phase two is given greater powers, authority, position, whatever word you want to use, than investment bank is normally given. Absolutely accept that. I also absolutely accept that there's nothing to stop you engaging an investment bank in phase one. I absolutely accept that as well. I do resist the proposition that in phase one, we should read this clause as if the investment bank is there in phase one, or if an investment bank isn't there in phase one, you are either in breach or likely to be in breach of phase one. That's what I push back on. My learner junior has passed me a note to remind me about the transcript.
Oh yes, good point.
And I'm
getting carried away.
I'm sorry, and I appreciate it's in the middle of an interesting discussion.
Yes, it is. But we'll take our break and we'll resume this interesting discussion in 10 minutes. Thank you.
All rise. rise.
Yes, Lord Robson, we had an opportunity to just reflect for a moment, and I think we, all of us, entirely understand the submission that you're making.
Thank you. Shall I therefore turn to breach?
Yes.
And say a word on that.
Thank you.
And as I do so, I will pick up a point which has been put to me by my Lord Justice Snowden, which I said I was going to come back to, and this is a convenient moment to do so. Just to be clear, when one talks of the obligation as to work together towards an exit in good faith, and what that entails, what you have to do, and conversely, what you can't do, the undermining point, I should make the point that working together in good faith towards an exit encompasses far more than the marketing of the company, whether through an investment bank or otherwise. Hiring a CEO, for example, to get the company into good shape is also part of working together towards an exit if you're going to either get an exit or get a better exit with a proper CEO in place. I mean, we all know that companies in the city get a chairman, for example, recognised by the city on the board if you're thinking about IPOing. Improving your sales can also be working together in good faith towards an exit. If a company is not doing well, the first thing you do if you want to work towards an exit is actually, so to speak, to turn the business around. Now, therefore, working towards an exit may involve engaging not at all with anybody outside the company, may involve not in not knocking on the door of an investment bank, not knocking on the door of any potential purchaser, not even putting an advert in the Evening Standard. It may, working together towards an exit, depending on how the company is situated, may involve the very simple process initially of turning the company round and, if I can use a phrase sometimes used in the city, dressing the bride, if I can put it that way.
Yeah, but that, but I mean, you've loaded a whole load of stuff in there. I mean, if there is not a requirement to work together in good faith towards an exit by a date, in other words, that's your target, then I can well see you might say, well, okay, let's hire a CEO first. But if you're given a choice, which is, look, you can do one or the other, but not both. If you say, well, we ideally would like a CEO in place, but that will take us a period of time, which means that there's no way we can then work towards an exit by the date. The point may be, I think, put that in which case you just can't hire the CEO. At least, you can't make that a condition of putting the company out. I mean, the way I think it's put against you would be that you can't, the company could not decide that it's going to delay working externally because of the desire to have a CEO.
Yeah.
If no later than 31st December 19 is attached to the words an exit.
I absolutely, and I have what my Lord Justice Edis mentioned ringing in my ears, but I hope I can just answer this question. And I absolutely agree that is the flip side, so to speak. But let us just consider the consequence of that. What that would mean is, in March 2019, you do go to an investment bank, you go to Goldman Sachs, you say, right, I want to work towards an exit for this company. And they say, right, what you need to do is you need to get, X or Y or Z as your CEO. And if you get them as your CEO, and you can do a sale in March 2020, and we are looking at a price of whatever. And you say, I've got to do this by the 31st December 2019. They say, well, that's no good because there aren't any good CEOs around now. And not having a good CEO is going to mean that you're not going to get that price. You're going to get a third of that price. That's a consequence.
Yeah, the investment bank would say, it's not the way we do it, but if you're contractually obliged to do it.
No, absolutely. But then the question is that likely to be what the contract means? That's why I keep coming back to that point.
But you're also ignoring the second sentence, and the point you've already made to us, it's not a breach not to have an exit by the 31st of December 2019. It's not mandated you have to have an exit. And all the company and the investors agree is to give good faith consideration to any opportunities for an exit. So, in the scenario we've painted, the investors could decide not to exit if the deal that's been put before them prior to the year end isn't good enough. They think they want a different deal, a better deal, because they wait. But why is it for the company in that scenario to deprive them of the opportunity to say yes?
Well,
that was a point I put to you earlier, and we've been around those houses. But I just, since you were coming back to me with your point, should we leave it there?
Yeah, I think where this argument pivots, standing back, where the argument pivots is how you read no later than 31 December 2019 brackets the quotes investment period quotes brackets. That's what the whole thing pivots on. Once you answer that, one way or the other, everything else.
Perhaps the two of us should both move on.
Yes, exactly. Really falls into place. Yes, I wasn't going back to it. I was just highlighting the point, which we're both now going to move on from. Breach. I'm just going to say a few words about breach because depending on how one interprets the contract here, one is likely to resolve the breach question one way or the other. But just to make the following points. First of all, if we are right on our construction of 6.2, then the judge's factual findings do not support a finding of breach. And I don't understand my learned friend to contend otherwise. The way he puts it in his written argument at paragraph 49, where he says there was ample evidence for a finding of breach, is premised on the judge's construction being correct. Importantly in this context, also, when I say also, because I'll obviously be coming back to this on the 172 point, there's no finding that Mr Costa didn't act in good faith. On the contrary, the judge finds in clear and unambiguous terms he acted with good intentions. And you've been shown the judgment at paragraph 208, which sets that out. I'm not going to repeat it, but that's where he says that he doesn't believe that it was Mr Costa's intention to injure anybody, and he did sincerely believe, and the joys of sincerely await us in the 172 context, that he was acting in the best interest of the company and its investors, and at 183 that he was pursuing an exit, but he wanted to get a good price and didn't expect that to happen until 2020 at the earliest. I get that from 164. So
that doesn't mean, does it, that he was not? That's not a finding that he was acting in good faith for the purpose of the first sentence of 6.2. That's all about breach of duty.
yeah,
They're different things, aren't they?
yeah, it is, and I hope I made that clear when I distinguished the first point I made about good faith from those points. And the judge doesn't seem to focus doesn't seem to deal with the good faith issue in terms of the first sentence of paragraph 6.2 in terms. I'll be corrected if I'm wrong, but that's certainly my understanding, which I think is the point my Lord is putting to me. And
I mean, we will come to 208 in the context both of duty and perhaps good faith as specified in the contract. Maybe it's convenient to do it together, because I think there's an awful lot in 208 that I think your assertion, if I've remembered it correctly, that this is there's no finding which could support a conclusion that there was a breach of the good faith obligation in 6.2 is quite a bold submission given some of what's said in 208.
we will come back to that. We will come to that. it's all going to depend, a lot of it's going to depend on what you analyse the obligation in 6.2 to be.
Yeah.
And certainly if it's put as high as my lord has put it to me in argument, then it's going to be more like it's going to be more likely there's a breach. If it's put somewhere lower, it's going to be less likely there's a breach. And on my respectful submission, there's no breach. So we will look at the good faith point later on because I'm going to need to deal with that in the context of 172 as well. What I was proposing to do now is to go to ground 2. And I should say that I think grounds 1 and 2 are the longest of my grounds. So hopefully we can speed up from here. And ground 2 is that the metric EOI, expression of interest, is not an opportunity for an exit capital E as defined. And so the first ground of appeal was the first part of the first phase of clause 6.2. The second part of the first phase is the second ground of appeal on the construction of clause 6.2, which is give good faith consideration to any opportunities for an exit capital E. And for these purposes, we don't need to get back into during the course of the investment period. And this turns on the correct meaning of exit in the contract. And my lords will have seen that exit is defined in the contract at page 514 of the contract as the sale of all, or substantially all, of 1, the issued equity share capital, or 2, business of assets, in each case on arm's length terms as part of a single transaction or a series of related transactions. Now, the facts are that Metric Capital Partners LLP, which I'll call Metric, submitted non-binding expressions of interest on the 13th of September 2019 and the 19th of November 2019. They attributed an enterprise value of $110 million to the company. And for my lord's note, those EOIs are at the core supplementary bundle, tab 16, page 84, and tab 17, page 87. Now, one might think, therefore, that the only issue for the court's determination on this ground of appeal is whether the metric EOIs were, in fact, contractually proposals for an exit capital E as defined. We say that is and ought to be the only question on this ground of appeal. In other words, if they did amount to an exit as defined, the company had to consider them in good faith, and if they didn't, then the company didn't have to consider them in good faith. The judge held, however, that there was a further question, which I'm going to call the subjective question, which arises, which is whether the company thought the metric proposal amounted to an exit. And the learned judge held that even if Mr. Costa were right about the metric proposal not being an exit, the company would still be in breach of clause 6.2 by failing to consider it, because the company didn't know at the time that it wasn't an exit. That's what I call the subjective question. And that's I get that from consequential judgment at paragraph 36. Now, I'll come to that point second. We say respectfully it's wrong as a matter of first principles, but I'll first deal with what we say is the real question under this heading, which is whether the metric proposals met the definition of an exit capital E. Now, the learned judge found, and we're looking here at paragraph 185 of the judgment, the learned judge found that a sale to Metric or another private equity house would have been effected through the purchase of 100% of the shares of the company by an SPV established for the purpose. He, in the same paragraph, goes on to say it's highly likely, he says, that some of the sellers, i.e. the existing shareholders, would stay in, i.e. reinvest some or all of the consideration received for their shares in the equity of the SPV. This is what's often called a rollover in the documents. In addition to what is said in 185, we should pick up at paragraph 48 of the judgment that when Mr Lloyd was attempting to originate offers, which led in due course to the metric EOIs, the basic model he proposed, this is the second sentence of 48, was that here Mr Flamini would contribute the equity piece, i.e. roll over their shares, and the private equity house would provide debt to finance the purchase of the other shareholders. My lords will be familiar with the way this is done. Mr Lloyd's proposal to metric, which was accepted, was that between 28 and 42% of the equity in the company would be rolled over. I get that from judgment 188. First half of the paragraph. And although the judgment doesn't actually record the progress of the discussions, we know from other documents that the eventual proposal required about a 50% equity rollover. I can show my lords that from a document in the core supplementary bundle at tab 15. At page 82 of the core supplementary bundle. That should be an email of the 15th of July 2019. The only point I'm picking up here is the under key assumptions in the second paragraph, equity value 100 million, and then the fourth bullet, existing shareholders management rollover of 56 million, and then the fifth bullet under key terms, equity split based on, that's metric, junior rollover capital investment, 41.59 split. We will want to include a price adjustment. So that's where it ended up. For the purposes of my argument, it doesn't really matter whether it's 35 or 45 or 55, because my argument is going to turn on all of those are not substantially all. Now, importantly, at paragraph 189 of the judgment, the learned judge held that a sale transaction which simply replaced one shareholder with another, so that the rolling over shareholders were both in a majority of the equity holders of the acquisition vehicle and were in the same economic position as they were before the transaction, wouldn't constitute a sale of substantially all of the company. That's the point the learned judge makes at 189.
So just try and putting that in language that a company lawyer would understand. If all the existing shareholders of the company were simply to exchange their shares for an equivalent number of shares in a new co, which would, after the transaction, simply be inserted between them and the company, that wouldn't be a sale of, within the meaning of the definition of exit.
Yes.
But if the owners of the shares in Newco, the acquisition vehicle, were
different,
completely different, there would definitely be an exit. And the question, which the judge attempted to grapple with, and I think you're about to grapple with, is where between 0 and 100 is there a dividing line, if there is a dividing line?
Absolutely. Well, I was getting a bit worried that my lord had seen my notes, because the first point my lord made about if there was a rollover of everybody was exactly the point I was going to make next.
Right. Okay.
But just in the avoidance of doubt, my lord has not seen my notes. But with respect, I absolutely agree. I would only say that there are, in fact, two questions the first question of where is the dividing line is another way of putting what does substantially all mean. The other question that arises, because of the way, I'm just dividing it conceptually, I'm trying to divide it conceptually. The other question that arises, because of the way the judge grappled with the question, is does it make a difference if you add a slug of subordinated debt or the equity piece is subordinated to some debt in the SPV? And let me develop that. Let me develop that. Because the way the judge approaches it is not actually to say, to answer the question, is substantially all 90 or 95 or 80 or 85? As I'm going to submit, on the judge's approach, if all the shareholders were to buy shares and get shares in the SPV in the same proportion as they had in the original company, which, pausing there, we agree is not for these purposes an exit on this approach, because you've merely replaced the first point my lord put to me. On the judge's approach, if you add some debt to which those same shareholders are subordinated, it does become an exit. That's the proposition which I'm going to seek to establish. And because in my submission that, if it's wrong there, it's wrong everywhere. And let me show you, my lord, how I'm doing this. But I certainly agree. It is common ground from what we might call a substance over form approach that if you replace all the shareholders in the same proportions in the SPV, that's not an exit. Why not? Now, it's because it's a substance over form approach. Now, to be clear, we do not say, and we've never said, that a transaction involving any sort of rollover wouldn't be an exit. To that extent, we agree with the judge and with Saxon Woods. Where we part ways is the basis for the distinction between a transaction involving a rollover, which amounts to an exit, and a transaction involving a rollover which does not amount to an exit. And we say, very simply, that the basis for the distinction is made plain in the express terms of the SHA. The exit must be of a sale of all or substantially all of either shares or assets. All or substantially all. And that requires, in our submission, that all or substantially all of the equity be sold as a matter of substance rather than rolled over into a new investment vehicle. Now, what does all or substantially all mean? It's fair to say that those words are interpreted in a number of authorities, but of course they all turn on very much their own contexts. There are a number of tax cases dealing with all or substantially all. There are different considerations in those cases, that's why I've not cited them. What we can, in my submission, say is this. First, all means 100%. Substantially all means something pretty close to 100%. Just how close it has to be is, in my submission, academic in this case, and the court doesn't need to decide where the boundary actually is, because wherever it is, it's certainly not 50%. Once you're talking of 40% plus, you're way outside, in my submission, all or substantially all. So we looked at the metric email of the 15th of July. The higher end of Mr. Lloyd's proposal to metric on the 6th of July was 42 or 43%. All of that, in my respectful submission, is way over all or substantially all. And just to make the obvious point, instead of selling share capital, if the company had instead sold assets, which is the other way of doing an exit, we wouldn't say the company had sold substantially all its assets if it retained 50% of them, or 60% of them, or 40% of them. And the position is no different with the rollover of share capital.
Right, so again, just trying to get my head around what you're actually submitting. In law, we're sort of assuming that 100% of the existing share capital will in fact be sold to a new co.
Yeah.
And what the percentages you're addressing is the percentage ownership of the share capital of Newco. And what you're saying is that unless Newco is 100% owned or close to 100% owned by completely different people than are the existing shareholders, it doesn't constitute an exit.
Yes, exactly. Exactly. And that's what I'm saying. This is the first part of the argument. This is the first part of the argument. Exactly. So the first part of the argument is...
so what you're saying is any retention of... Sorry, any...
rollover.
Yeah, I don't want to use the word rollover.
Sorry,
it's
okay.
just too much of a label. If any of the existing shareholders of the company have more than a fairly minimal investment in the bid vehicle, Newco, it's not an exit.
Well, my lord, yes, that is my argument, because they haven't entered it. In the sense that the argument that, well, they're in an SPV, that's not a relevant argument, because we accept that if they all go into the SPV, it's not an exit. Yeah? So once we accept that if they all go into the SPV, it's not an exit, then my argument is, well, if substantially all go into the SPV, it's also not an exit. Or, and then I've got to put it in a negative, which is the point my lord has just put to me. If an element, which means that substantially all have not left the original company, then it's not an exit. I put it less elegantly than my lord just put it.
Well, I just think you put it wrong.
I may have done.
I know what you meant
Yes.
to say. Is what you're saying is if a significant number of the or proportion of the existing shareholders by shareholding become shareholders in Newco, then it's not an exit.
Yes.
And when you use the word significant, it's something which is more than...
Which is the opposite of it's a negative. Exactly. We're using significant to be the mirror image, so to speak, of substantially all. The significant is if
so 25% say.
I don't want to put a number on it, but I don't need to for these purposes for the reasons I've just given. But let's just say 25%. We now actually say substantial is probably high, but let's say 25% for the sake of this discussion. If 30% have rolled over, have got shares in Newco, then that is not an exit, because not all or substantially all has been sold. Yeah. But it's very important, obviously, for that argument to clear away it's a Newco, it's a different company, because we all accept that at the 100% level, that argument doesn't pertain. Now, the learned judge holds that it was an exit, and this is at 256. And the basis for the learned judge holding it was an exit, and in my respectful submission, his reasoning would have to also apply to the 100%.
So which paragraph?
So 256, my lord. Oh, is that the right?
No, I don't think it is.
No, it isn't. No, that's a wrong. Oh yeah, sorry. Yes, just looking at the first, I think my eye went to the bottom, so I'm looking at the first bit of 256. It's clear that the initial non-binding offer metric was in fact received during the period. For the reasons set out above in 185 to 191, I regard this as complying with the requirements for an exit. So we're going to be sent back to 185 to 191.
Yeah.
And that's where I was now going to go. So we go to 185 to 191, and that's where you have the heading, what is an exit? Capital E. And as my lords have seen, having read the judgment and the written arguments, the basis for the judge's distinction between a transaction involving I was going to say rollover, a purchase of shares in Newco, which was an exit, and a transaction involving a purchase of shares in Newco that was not an exit is the capital structure of Newco. And we get that in particularly from 189. If the position were sale transactions simply replace one shareholder with another, so the rolling overs were both the majority of the acquisition vehicle and the same economic position as they were before the transaction, I'd agree it didn't constitute a sale of substantially all of the company. That's the point we've been discussing. And then he gives an example on a 60-40 basis. But he goes on to say the position is entirely different where the purchase is made by an SPV whose capital structure is entirely different than that of the target company. It's misleading to speak of shareholders rolling over. They're selling an investment with one particular set of characteristics, acquiring another with a very different set of characteristics. The rolling over shareholders will not simply have reacquired the interest which they previously had. They've become the owners of a relatively highly leveraged Newco. Economics are different. Claim to the profits are subordinated to new debt, and the risk-reward profile is entirely different. Now, and then carrying on into 190, he refers to my learned predecessor's submission that the substance of the deal with Metric was that Saxon Woods would retain its shares in the company, not sell them. It's wrong. We would have given up the shares in the company and acquired shares in an entirely different entity. Well, just pausing there, that applies with 100%. So the relevant bit is the next bit, with an entirely different economic structure. And he makes it clear it's the fact of this substantial change in economic structure which demonstrates the proposed transaction was a disposal to a new entity and not a retention of an existing investment. And our submission is that by these paragraphs, the judge added an extra layer to the definition of an exit, which simply is not in the contract. That a transaction which is not otherwise a sale, i.e. a straightforward transmission from the original company to Newco, where we say that's not a sale on a substance over form approach, can be transformed into a sale or into an exit by the terms of the capital structure of the acquisition vehicle. And for all the talk of an entirely different capital or economic structures, what it really boils down to is the fact that the shareholders who've taken shares in Newco, their profit claims as shareholders are subordinated to debt introduced by the sponsor. And we submit that there is no principled reason why this makes an equity, I was going to say rollover again, but an equity transmission, an exit, in circumstances where absent this subordination of economic interests, it wouldn't be an exit. Because as I say, the judge's approach logically has to apply if all the shareholders went into Newco. If the judge is right, it doesn't depend on the fact that 40% did or 60% did. It would apply if they all did. And if they all did, it would not be an exit. And we would not be an exit regardless of whether a slug of debt was introduced as well. And the reason is simple, because the investors' interests are still ultimately tied to the success of the company. It's not an exit from an investment in the company. And as I say, the fact that they're in Newco is not a relevant point because we all accept if 100% go into Newco, it's not an exit.
Well, so the debate that I'd been having with you was on the proposition that there was a simple insertion of a extra corporate vehicle. We hadn't really started to discuss the point we're now on, which is if the corporate vehicle is not just, as it were, a Newco shell being inserted, but in fact has, as the judge points out, very different economic characteristics. Where, for example, the share structure may be very different, and the debt structure may be very different. So, that's where we're at. We started to introduce it. You keep on going back to say we all accept that if it's just 100% transfer, but I think certainly my understanding of that proposition that we were debating was that it was nothing more than a shell company with no other external financing or other forms of share capital or otherwise associated with it. It was just a shell.
That's absolutely my understanding as well. And exactly. I was putting it deliberately that way, just to take it in stages. And as we need to clear off the table the chimera of, well, of course it's a sale because it's a new co.
Right.
That point in and of itself isn't available. The real question is the economic interest point. That's why I'm focusing on this.
Well, when you say it's a question of substance over form, you're really, in a sense, saying economic substance over legal form is what this clause is actually all about. And if it's economic substance over legal form, you can't just say, well, the shares are being acquired by a new co, and that's an end of it. Then why do you not start looking at the debt structure of the new co and any other interests in new co as well?
Yeah. Let's just be clear, and I think this follows from my Lord's question, but just to be absolutely clear what my submission is. My submission is that if the judge is right, this must logically follow. If the judge is right, then the slug of debt in NewCo to which the investors' profit claims are subordinated, which is the judge's reason for saying this is an exit, would apply even if NewCo was owned by the same shareholders in the same proportions. Logically, in my respective submission, that has to be right. In other words, if that's the reason to change what would otherwise not be an exit, because it's simply a NewCo, bare NewCo, into an exit because the economics are different, that will apply regardless of what percentage of the existing shareholders have gone into NewCo.
Well, are you assuming that they all also take a piece of the debt in the same proportion? I mean, I understand your point that if the NewCo is simply owned by the same shareholders in the same proportion and they each make a loan to the company in exactly the same proportions as well.
No.
What assumption are you making about the ownership of the debt?
The judge's assumption, the judge's point, and the bit I just read out, is the reason why this is different is because the rolling over shareholders are now in a NewCo with debt put in by the private equity provider to which their profit shares are subordinated. It's a highly leveraged vehicle.
Yes.
My example is, the only point I'm making is, it must necessarily follow from the judge's approach that if 100% of shareholders in the same proportions moved into NewCo and the private equity provider put in the debt into NewCo, to which they were all their profit claims were subordinated, it would still not be it would be an exit on the judge's approach. That would be an exit. Mm-hmm. That must follow. Mm-hmm. Must follow logically. Now, that means that on the judge's approach, that would be an exit even though all the shareholders have stayed in the same proportions, and what has essentially happened is that the company has taken on some new debt. I appreciate it's NewCo, but it could have been done in the original company, which the existing shareholders have all agreed to stand behind. And therefore, on the judge's approach, a sale would not be an exit, even if the existing shareholders control the acquisition vehicle, and even if they're in the same position as regards their shareholdings as they were before. And we respectfully submit that on the wording of the contract, it is simply wrong to say that by introducing an amount of subordinated debt, or debt to which the shareholders are subordinated in the SPV, which is essentially the judge's reasoning, it is suddenly an exit. That's because the judge is focusing on the wrong distinction. It's not about capital structure. The only question is whether the all or substantially all requirement is met. And we say simply based on the words of the clause, a deal in which a substantial chunk, or significant, to pick up my Lord's words, of the investors stay in is not an exit, and that's because they haven't exited. Now, just to be clear, of course, it doesn't mean that you can't do a deal like this. You can do a deal like this. It just wouldn't be an exit capital E. So what it means is that you can do a deal like this, but you would do it without the benefit of the compulsion in the SHA, because it isn't an exit as defined. Just to take that a stage further, what that means is if the investors who want to exit want the benefit of compulsion, which essentially is what you get by the definition of capital E exit, it has to be an exit as defined in which everyone or almost everyone is coming out. And that's where we say the fairness aspect of this comes in. And we see the draftsperson is thinking about fairness because he's talking also about arm's length terms. A rollover treating groups of shareholders differently. A rollover involves treating groups of shareholders differently, depending whether they're staying in or getting out. And although it's not uncommon, therefore, for purchase to require a rollover, if you want to do that deal, you've got to get really everyone or almost everyone on board. But not every offer is going to be an exit. Capital E is defined. As I say, there's nothing to stop you agreeing to it. You just can't drag along anyone who doesn't want to do it. And so that's our sort of first main submission on exit. It's rooted absolutely in the words of the bargain. And if, I'll use the word significant, if a significant number of investors are staying in, it is simply not an exit. And that doesn't change whether you add a slug of debt to which their profit claims are subordinated. The other problem with treating capital structure as the basis for the distinction, as the judge has done, is that it makes the question as to whether there is an exit as defined dependent on, first, what the rolling over shareholders are prepared to agree to force out the existing shareholders, and or the buyer's demands to protect their own investment. Now, both of those are issues over which the exiting shareholders have no control, or virtually no control. And the effect, therefore, is that the power to determine whether a transaction is or is not an exit lies with the investors who are staying in, or the third-party purchaser, who's a stranger to the contract, and not with the investors who are coming out, who need the protection. In other words, you can transform something which wasn't an exit into an exit by agreeing with the private equity provider to put in some debt on top. And who knows what's going to happen to that debt in the future. You can unscramble it, you can do all sorts of things with it. But, mirabile dictu, you've transformed this deal, which wouldn't have been an exit, into an exit by adding in that slug of equity on top. And the exiting shareholders have got no control over that.
If the purpose, or if the construction of 6.2 is that there's no particular deadline, and the purpose is to try and get the best price reasonably obtainable in the market for these shares, because the investor's interest is getting their money back, why does it matter that, assuming all the shares are being legally sold, and therefore consideration is being received for the full amount of the shares, and that's the best deal that can be obtained in the circumstances, why should any investor care whether the purchaser has behind it some of the investors or not? However, on the contrary, I can see an argument that it does matter if this isn't a process which is to get the best price obtainable whenever it might be obtained, but is putting a date by which it must be achieved, therefore might be, by definition, less than could be achieved if you waited. I can see then it might be, well, the price of that is we're all getting out.
Yes. Well, that, to a certain extent, that gets us back into...
No, there's a link between the two.
There is a link between the two. Of course, without going over the 6.2 territory, the fact that you're getting the best price reasonably obtainable today still doesn't mean that you are necessarily happy to come out, even if you're a financial investor. Because if you consider that the time value of money is X over the next 6 months, but the potential increase in the value of the company is 2X over the next 6 months, then even if today you're getting the best price reasonably attainable, if you can afford, so to speak, to wait and stay in, you would do that, because the alternative is putting your money on the money markets and getting X. So I absolutely see where my lord is coming from, but even on that hypothesis, it doesn't necessarily follow that just because you're getting the best price reasonably obtainable today, you're always happy to come out today. That's in addition to the point my lord put as to, and I see the point, as to the impact of this point on the two alternative constructions of 6.2, which I absolutely see.
Can I sort of follow that one up? Just trying to understand what's behind this. I mean, one presumably starts from the proposition that people should only either be forced to sell or would only want to sell their shares for the best price. I mean, commercial people, you want to get the best price of your shares. This is a people business, isn't it? This company is a people business. It's not making widgets.
Yeah.
It's
Providing
fashion,
services.
design, style. Yeah. And in that sort of scenario, why should the parties to this agreement have envisaged that an exit should require everybody who has anything to do with this company, in terms of being equity investors who are the dominant forces in the company, to have nothing to do with the buyer? Because most buyers would actually want to buy the company for the people who are associated with it to a greater or lesser extent, because that's what constitutes its goodwill, business, and everything else. I mean, your interpretation of exit presupposes that the people going into this contract only intended that they should work towards all of them just have nothing more to do with this company and its business. I mean, that's quite a striking scenario in this type of company, isn't it?
The two answers to that, my lord. First of all, they both pivot from the same point. The first answer is that you have the all or substantially all requirement in order to make sure that the people who are leaving and are not staying in are treated absolutely fairly.
Yeah, but in your definition, what the company has to work and everybody has to work towards is a sale to an entity with which
most people,
all or substantially all of them, are not in any way involved.
Yeah. I absolutely see, with respect, my lord's point, but
which won't give the best price. But, or is unlikely to, because most people will pay for the business with, and you will normally want to give an earn out, or at very least retain the people.
And of course, you can, first of all, you can do that deal. You can do that deal. You just got to get everybody to agree. It's not an exit, capital E. You can always do that deal. If everybody's getting the best price and 40% are leaving and 60% are staying, by which I mean going into Newco, you can do that deal, provided you get the shareholders to agree to it. You just don't get the benefit of capital E exit. That's the first part of the answer. The second part of the answer, though, is this. Let us just consider what are the consequences of that approach as a matter of contract. Let's put to one side any debt introduced by the equity provider. Let's just ignore that for the moment. What that would mean is, another way of putting my lord's question is, well, if 60% or 40% go into the new vehicle, is that an exit? Because the point my lord makes is a point which is independent of whether the private equity provider has actually put it in any debt or not.
Yeah, I was trying to look at it slightly differently. Maybe it's the same way. If you look at clause 6.2, and as I recall it, sorry, I had it up on the screen a moment ago. Try and get it again. My computer wakes up. There it is. If you look at 6.2, 6.3, which is where we were, apparently everybody has to work in good faith towards an exit, and if one isn't achieved by a certain time, you get an investment bank in to dictate the terms of an exit. But apparently the one thing you've got to work towards and tell the investment bank it's got to achieve is a sale to a company with which pretty much everybody can't be associated, or at least can't have any sort of economic involvement.
If it's going...
Why?
That is... Well, first of all, the short answer is that is what the parties have provided. And the reason is in order to protect those who will not be going on. And to come back, when my lord talks about it's a people business, the people business are the employees. I mean, those are the relevant people. The people business are the employees, not the financial investors in the company. The success of these companies depends on, if you're a people business, it depends on who's, so to speak, making the coffee. It doesn't depend on who's owning the shares in Starbucks.
No, maybe I misunderstood the history of this company, that I thought it was far more, a number of the characters in this case are far more dominant than just being passive investors funding people to make coffee.
So, some are and some aren't. There are also financial investors in there as well.
Apparently none of them can be involved in the entity which everybody has to work towards getting. And indeed the investment bank is told, you absolutely cannot arrange a sale to any entity which has more than a insignificant number of the existing people associated with it.
Yes, and that is what sale of all or substantially all means.
And I was just querying when the parties were sitting around negotiating these terms, because that's when we have to actually to sort of...
Yes, exactly, when the contract is written.
Why should they want to think that is the exit, that they would serve their interest best?
Because if you're financial investors, and by this stage they were looking at it on a financial basis, then, as my Lord Justice Zacaroli puts it, what you're concerned to get is the best price you can get for your investment. And that, there's a wrinkle on that as to say whether is the best price today the best price if I can get a slightly better price tomorrow. That's a different point. But what you're focused on is a financial return on your investment. And all or substantially all means and has the effect of treating everybody fairly. And the problem with the alternative approach, to say, well, it's always contemplated that some people would roll over, is that what meaning do you give, therefore, and let's ignore any debt which comes in from the private equity provider, what meaning do you give to all or substantially all? I ask rhetorically. You end up with that devoid of meaning, or you really are rewriting the bargain. It would mean exit means the sale of what? I mean, it's simply, in my respectful submission, impossible to rewrite that. And it's particularly impossible to rewrite it when all or substantially all refers not only to shares but also to business or assets.
Well, does it? Because if all the assets are sold, they are actually all transferred to a new co. Yes. Why does it matter that the new co is part owned by the original shareholders? All the assets have been sold, haven't they?
Yeah. So if you did an asset sale, one point we did think about, it's an interesting question. If you do an asset sale to a new co owned by the same shareholders, would that be an exit as defined? And in my respectful submission, if you start from the proposition that a share sale to a new co owned by all the shareholders in the same proportions and ignoring any new debt would not be an exit, it would be odd that if you transfer the assets as well to that new co, as opposed to a new co owning the shares, and then transferring the assets as well would make it a sale.
Well, this may be why there's a false premise in your argument, which is we start from the proposition that if it's everybody, then it's clearly not a sale. Therefore, it follows that. Because as soon as it's not everybody, there's a difference. It couldn't possibly be called a sham transaction, for example, because whereas it might be if everyone's involved on buyer and seller side in some way. But if they aren't all involved, there's no question of sham then, where there are different entities. One has a different makeup of shareholders to the other, so there is a clear, real transaction.
Yes, and if of course just take that a stage further, if one does have, well, two points. First of all, so far as I understand it, the point I made about if everybody was to roll over or go into NewCo, it's not an exit, which was a point accepted by the judge, as indeed the premise for his argument. My understanding is that that's a point accepted by my learned friend as well. And of course, my lord is not bound by any of that, but that explains why I'm arguing it on that basis. To deal with my lord's point, if one was to have a sale of assets, there is another protection for everybody in a sale of assets, because you've got actually to value the assets. You know exactly what's being sold, you're valuing the assets. I'm focused on a case where they haven't done a sale of assets, whether to a company in which everybody's involved or only half the people are involved. I'm dealing with a case in which only some people have rolled over, and where certainly in my respectful submission, if one just stopped there, in a case where 50% roll over, there's no additional debt put in by the equity provider, and there is no sale of assets. In my respectful submission, it will be clear that that does not satisfy the definition of exit, because in no way can that be a sale of all or substantially all of the issued share capital of the company.
But to pick up your point, because I think you just put it as an answer to my lord, that in legal terms it is a sale of all of the shares. Why isn't the protection provided for people in those circumstances that it would be a sale on arm's length terms? I mean, you say, well, if an asset sale is different because the protection is there would be an actual sale. I think that's what you said a moment or two ago. But in fact, it's in each case on arm's length terms. I mean, it's only an exit if the terms on which the shares are sold are at arm's length, which in fact presupposes that it's to a third-party buyer. So it has to be the same terms as you get selling into the market to a third-party buyer, because that's what arm's length means.
Yes, but on that basis, what is the function? I don't wish to ask my lord a question, but one has to grapple with the question, what is the function of all or substantially all? Because on that basis, you don't need all or substantially all at all. You just say an exit is where there's a share sale, and you're given the protection by the arm's length term.
No, everybody has to be entitled to sell for it to be an exit. In other words, it has to be for all or substantially all.
But here we're not dealing with everybody being in. Well,
you have to work together towards an exit. So the company has to work towards getting a transaction together.
Yeah.
Where everybody, or all or substantially all of the shareholders can participate in it. Because, the company is there to do the job for all or substantially all of its members. And the protection against an artificial transaction is it has to be on arm's length terms. I mean, what couldn't happen is that the company and the shareholders are not obliged to work towards simply a sale of one person's shares.
yes.
I mean, is that?
Well, where we now are is a position which is neither the bedrock of that contention moves away from the judge's starting point, which I understood to be the starting point of myself and my learned friend, that the 100% rollover would not be an exit. Because on that approach, the 100% rollover would be an exit.
Well, if the 100% rollover was just a share-for-share exchange, in a sense, I'm not clear whether that's really on arm's length terms. It's just swapping share for a share, just putting a new subsidiary in place. I mean, that's not a sort of arm's length sale. That's just a corporate restructuring.
Well, a purchaser comes along and says, I will put in 2% of the equity. I'll put in 2%. I'll buy 98%. That would be an exit on this basis.
So I'm not sure I've understood what the what the purchaser is offering to do there.
Yeah. We're, as I understand it, we're moving away from the proposition that the 100%, what I'm calling rollover, would not be an exit. Because if it's done on, if the relevant price they're getting is an arm's length price, on this hypothesis, it would be an exit, on the way what my lord is putting to me. That must be right, in my respectful submission.
I suspect we're not quite in the same place because of the concept of rollover. If by rollover you simply mean a new co,
Yes,
owned by
98%.
98%,
Of
which
the-
just offers a share for share, that's one thing. But if you have a third party coming in and offering shares of value in its issuing shares of value in itself, it's an existing company.
Well, if it's a shell, sorry, I don't want to go over the time, but we'll have to continue this. But if it's a shell, and the purchaser is saying, "Here's a price for your shares," it's an arm's length price, and 98 move over to the NewCo, take shares in NewCo, use their money to buy shares in NewCo, then on this approach, it would be an exit. And certainly on the judge's approach and my approach, and I thought my learned friend's approach, it wouldn't be. But perhaps we are trespassing on
Yes,
time
I
for the
think,
short adjournment.
we will come back to this later. Where are we? Yes, we'll say 2 o'clock.